Now let's understand this. Except where the provisions of paragraph 3 of Article 7 business profits apply, the taxation on a PE which an enterprise of a contracting state, let's give this US, has in the other contracting state, let's say India. So until now what it says is, if a US enterprise has a PE in India, the taxation of that PE shall not be less favorably levied in that other state, which is India, than the taxation levied on enterprise of that other state carrying on the same activities. What this implies is simply that once a foreign company has a PE in India, when you calculate the profits of a PE, the benefits which a PE should get should be at least equal to the benefits which a local resident gets. The PE may get some more benefits also, and that will not be construed as a discrimination against the local enterprise. And even if it is, that is not something which is dealt with in the non-discrimination clause, right? But this is subject to provisions of paragraph 3 of Article 7. What this does is, this basically deals with the deduction of expenses when you calculate the profits of the PE, which means when provision of paragraph 3 of Article 7 provides something contrary, right, then those provisions are going to override what is discussed here. But otherwise, you cannot subject the PE to a treatment which is less favorably. Less favorably is different from other or more burdensome, right? What this means is that there is a material disadvantage, right, between the tax benefits which are given to a local enterprise and a PE, right? Levied means both the collection and the assessment of taxes. Same activities, like I told you, when we compare PE with ICO 1, both of them are into IT activities. Therefore, they will be comparable. But if we compare it with ICO 2, which was into manufacturing, that is not a same activity, and therefore, if there are benefits which are given to manufacturing companies, the PE may not claim it. But if there are benefits which are given to the IT companies, the PE can claim it. Now, there is no mention here that the rules cannot be different. As long as the rules which apply to a PE result in taxation which is not less favorable than what it is given to an Indian company under same circumstances, that is okay, right? The provision shall not be construed as obliging a contracting state, let's say India, to grant to residents of the other contracting state, which is US, any personal allowances, reliefs, and reductions for taxation purposes on account of civil status or family responsibilities which it grants to its own resident, right? So if, let's say, for example, India were to give a benefit that, because of the fact that you have a child who is going for education to school, we'll give you a deduction for that, right? It's not necessary that they have to give that deduction to a US resident also who's placed under similar circumstances. They may give it, it's a different matter, but if you are giving them on the basis of civil status or family responsibilities, those benefits need not necessarily be given to the person who's a resident of the other contracting state.